Right. Welcome back to C2C Journal. Today we're tackling a crucial question. How did Canada, once committed to a clear and robust vision of free speech, begin to lose its way? Joining us here today is Josh Dehaas, a constitutional lawyer and an author of his recent essay, The Road to Censorship: How Did Canada Lose Its Way to Freedom of Speech? In his thought-provoking piece, Josh walks us through the court decisions that have slowly eroded Canada's protection for expression. He explains how shifting legal interpretations have allowed government bodies, from city councils to Parks Canada, to cancel events or deny permits over fears of the so-called harmful expressions. One striking example he highlights is the case of American Christian singer Sean Floyd, who was banned from performing in Canada before he set stage to perform. Josh, it's great to have you. Thank you so much for joining us.
Thanks for the invitation.
Of course. Well, let's dive right into it. So, you open your essay by discussing the history of the legal framework behind free speech in Canada. Can you give us a brief breakdown of how it developed and where it stood before these shifts began to change?
Yeah, so Canada's freedom of expression law, its freedom of speech law, actually originates all the way back in ancient Greece. So Greeks, the Athenians realized that if you're going to have democracy, if you're going to let everyone have a say in how the state is governed, people need to be able to speak boldly. They need to be able to say things that other people find offensive or that are controversial. So that's really where free speech originally developed. And then, fast forward a millennia and a half, and in Europe it starts to, reemerge after a fairly dark period of little free speech with the advent of the printing press. And it gradually becomes part of the United Kingdom's laws. And by 1867, when Canada becomes a country, as a Constitution Act states, similar in principle to the United Kingdom, we inherit the UK's free speech. And this gets made very clear in a 1938 Supreme Court case called the Alberta Press case, which was a challenge to Alberta's law that censored newspapers and said that the newspapers could be forced to print government corrections. And here the court says, no, we inherited this principle of free speech with the rest of our constitution from the UK. And so everyone has a right to untrammeled public opinion and expression in support of democracy and self-government. And there are some really good court decisions in the 1950s, all of them involving Quebec, where the Supreme Court says that laws Quebec has made, for example, Quebec City has a law that says the police chief has to approve pamphlets. That is struck down as unconstitutional because it's targeting the ideas and the spread of ideas in a democracy. There's a case, Switzman and Elbling, where the court strikes down a law that is supposedly an act against communistic propaganda, but is really just an act where the attorney general is allowed to shut down any, religious minority or political group that he doesn't like. And the Supreme Court says that also is unconstitutional because in free societies, you can't target the content of people's ideas. So fast forward to the Charter of Rights and Freedoms passed in 1982 that says everyone has a right to freedom of thought, opinion, belief, expression, speech, etc. You would think that the court would be able to see that this clear line had already been drawn where, you can regulate things like littering in the streets of Quebec City, but you can't regulate actual ideas, or you can't target the ideas in those pamphlets. You'd think the Supreme Court would pick that up. But instead, they go down a wrong path where they say everything that you do that is an attempt to convey meaning is protected speech. And the Chief Justice at the time, in this case called Irwin Toy, he says that even includes parking a car illegally as a form of protest. But parking a car illegally as a form of protest is not freedom of speech. It's, it could be speech, but it's not the type of thing that freedom of speech is meant to protect. It's meant to protect the expression of ideas. And so if you have a law that targets the form of speech or expression, in this case, a law against parking illegally, there's nothing unconstitutional about that. So that's the main distinction here is that, certain forms of speech or certain immediate physical consequences that you're trying to prevent, like a riot, is not targeting the ideas, but the Supreme Court fails to recognize that, and as a result, they apply a proportionality test to basically every free speech case, which in the end means it ends up being up to the judges to decide whether the speech, whether the positive nature of the speech outweighs the deleterious effects um, limiting that speech. So suffice it to say, basically, the Supreme Court fails to identify a principled way of deciding when the state can limit speech in the post-charter era, and that leaves it up to judges to decide in an ad hoc way, and now it's become completely unpredictable.
Right. So, when did the shift towards broader interpretations of harmful expression begin? And what were some of those key cases that were involved in that?
So where things start to go wrong is this case called Irwin Toy from 1989, and this was a case where the government of Quebec had said that advertisers can't target certain advertisements to children. And this should have been a relatively easy case because young kids don't have independent, free speech rights. But this is where the Chief Justice makes this mistake where he fails to draw this principal line. He says basically everything counts as expression, and so we're going to decide on sort of a case by case basis whether the government's law is proportional, the limit on the speech is proportional to the harm to the person who gets censored.
Mhm.
And then the following year is sort of the biggest free speech case in Canadian history. It's this huge battle over hate speech. So Canada's had this law since 1970 that says that if you willfully promote hatred against identifiable groups, minorities like Jewish people or Muslims or, um, you know, African Canadians, you could go to jail for, up to 2 years. And in this case, James Keegstra was a Alberta teacher who had been saying horrible anti-Semitic things, and nobody disputes that he should have been fired from his job. But the question was whether, in a country that has free speech, where everybody is supposed to be able to say things that others find offensive, so that we can, govern ourselves and debate things freely, should you really be putting anyone in prison for their words, no matter how vile other people see those words to be? So, in a 4-3 decision, this big battle happens, and Chief Justice Dixon wins. He says that if the speech is harmful enough, then it can be limited in a free society. Justice Beverly McLaughlin for the minority disagrees. She says, people don't know what hate means. That's hatred's in the eye of the beholder.
Mhm.
At the end of the day, these are just words, and it's, harmful actions like, actual violence are the types of things that you should be imprisoning people for, not for their words. And if you do this, you're going to chill all kinds of speech because people won't know where the line is between speech that's allowed and speech that's going to end up with you behind bars. But Chief Justice Dixon wins, and things have been pretty bad in our jurisprudence since then.
Right. So, can you explain how these changing legal interpretations started to give government bodies more power to restrict freedom of speech in Canada?
Yeah, certainly. So if you look at the Keekstra case, for example, it says that there are a couple of harms that the government is trying to prevent here, and as long as they're doing this in a relatively proportional way, we're going to let this stand, even though it ends up with it's obviously censorship if you're putting someone in jail for their words, or
Right.
even if you're saying that they've violated a human rights statute and have to pay a fine potentially. That's violating their free speech in my view, but the court might uphold that. The problem is you can't know in advance what the court is going to find, what the court's going to see as proportional. Or in the case of administrative bodies like a human rights tribunal, you're not going to know in advance how they're going to balance somebody's free speech rights against somebody else's claim to something like equality. So that lack of clarity makes it really easy for governments to just say, well, we're doing this in the name of equality, and courts will generally rubber stamp that.
Right. I mean, it sounds like the lines are getting more and more blurred.
Indeed.
Yeah. So in your essay, I mean, a big example you discuss is the case of Christian singer Sean Floyd, whose events were canceled by Parks Canada. Can you explain what happened there and why was this case so significant?
Yeah, so Sean Feucht is an American Christian singer. He's associated with the MAGA or, Make America Great Again movement. So he's quite far on the right. He has a lot of views that people find controversial on LGBT issues. And, other people don't find those controversial and they agree with Feucht and they want to, go to his concerts and hear what he has to say. Much to my surprise, after a small group of people complained about a concert in Halifax that was being held on Parks Canada land, Parks Canada decided to pull his permit. And it was very obvious why they did this. They did this because people were complaining that they didn't like his potential speech that he might give because he's said things like, Pride Month is demonic, or people who support gender transitions for children should have a millstone around their neck. That's his most notorious comment, I think, referencing a passage from the Bible. So Parks Canada said he can't perform there, which is obvious, viewpoint-based or content-based discrimination. They didn't offer any real evidence of any safety risks. And then municipalities and other public bodies across the country, with a couple of exceptions, notably, in I believe Saskatoon and the Alberta legislature, also agreed to cancel his concerts from public space. So, if you are a controversial, I don't know, rap group, or maybe you're a drag performer, you will almost certainly be allowed to play your show in public space or perform in public space. But if you're Sean Feucht and you have views that certain people on the left don't like, apparently you're not allowed to sing in Canada. So that's a clear violation of free speech. But governments may be able to get away with it by just claiming that they are working to support equality.
Right. Where did that, I'm just curious, where did that case land? So it was his shows were canceled and that's pretty much that. Did he try to fight it? Was there some sort of resolution or that was pretty much it for him?
Yeah, so he's certainly fought back in some cases. The most egregious thing to happen, I believe, is that when one of his shows was relocated to a church in Montreal,
Mhm.
the church was actually fined $2,500 by the
Oh,
city
wow.
for not having the correct permits. I mean, the city argued that this is an unorganized concert, but it's also the normal use of the church to host parishioners at all hours and have people sing and people pray. So it strikes me as an unconstitutional ticket laid, and I've heard reports that he's fighting that in court. I've also seen potential, warnings to various cities that were considering canceling him that there might be legal action. So we'll have to see what happens with those.
Absolutely. So, in your opinion, what does this case reveal about how officials decide what counts as harmful speech?
I think that they decide based on popularity, which is the worst possible scenario because, freedom of speech doesn't exist to protect opinions that everybody likes or that everybody thinks are popular. It exists to protect people that want to have a say, even if their opinions might rock the boat or ruffle feathers or challenge the status quo.
Mhm.
So, if politicians make decisions about who can speak, and that is what you're doing, when you're at a concert, that is expression. It's the same as, giving a political speech. If they can decide who gets to speak and who can't in public space based on popularity, then we really don't have much free speech at all because it's a right that's there to protect, minority viewpoints essentially, because sometimes in history minority viewpoints end up being right in the long term, and we only figure that out if people are allowed to express them.
Absolutely. So, how do these legal changes affect, ordinary Canadians, not just artists, and public speakers today?
Yeah, so Justice McLaughlin, in her dissent in Keekstra, she warned that there would be a huge chilling effect if these hate speech laws were allowed to stay on the books. And she said, people won't know where the line is between what is considered protected speech and what is considered, hateful speech that could land them in jail. And what we've seen is more and more things that, you would think are reasonable things that you should be able to say in a civil conversation with someone are now considered discriminatory and hateful by someone out there. And they're often able to run to their political leaders or the media and claim that this person should not be allowed to speak and get them censored. One recent example comes to mind in Hamilton, Ontario, where a group called the Association for Reformed Political Action put up a billboard that points to a website that says, "Let kids be kids."
Mhm.
And this was considered hate speech because this website says things like, kids can't consent to lifelong changes to their bodies, or um, basically statements like that that argue that there shouldn't be gender transitions for children. Like, whatever you think about that,
Mhm.
you should just argue the opposite. But instead, people complained to the mayor, Andrew Horvath, and she actually got the billboard taken down,
Oh,
preventing people from even having this conversation in a civil way. So that's where we're at now. If you complain to your politicians, they'll censor your speech. The courts will often uphold the politicians because that's how the law is. It's too vague and unclear, and they're allowed to decide sort of in an ad hoc way what value they want to preserve here, the person claiming discrimination or the ancient right to free speech.
very interesting. I mean, it's definitely a very interesting topic because we do live in Canada where we pride ourselves with having free speech in comparison to some other countries where free speech is not allowed. And it sounds like we're heading towards that direction of other countries where only one viewpoint is allowed to be heard and publicly allowed to be presented. So that's definitely very, very concerning. What steps do you suggest to restore clarity and stronger protections for freedom in Canada?
Well, I think the first step is for people to educate themselves. So go and read that C2C journal,
Yes.
C2C journal article. It's more than 5,000 words, but it explains it all. And once you're educated about that, you can go and argue to your fellow citizens that, we do need free speech. We need it so that we can get to the truth. The prevailing opinion isn't always right. And societies that have free speech have progressed a lot more than those where censorship is allowed to continue. And if you do have your free speech violated, you can try and contact an organization like the one where I work, Canadian Constitution Foundation, and we'll try to help you if we think you have a case, and we can step in to fight it. But the best place to fight this is talking to your friends and neighbors, and then also pushing back against the governments, because if the governments don't put in place these censorship laws, if they're afraid to do that, or they understand the value in minority viewpoints or viewpoints with which they disagree, then we'd be in a lot better place, because at the end of the day, it's the government that really has a lot of the power here.
Right. Absolutely. And finally, what is your main takeaway from your essay for Canadians concerned about free speech in our country?
Well, I think the main takeaway is that unfortunately we're a lot further along the line to a really censorious country that doesn't have free speech than people tend to realize.
Right.
The government is repeatedly getting away with this, and sometimes the courts will step in and side with free speech, but the current state of the law doesn't really require them to.
Mhm.
Things are a lot worse than people realize. We're a lot more like China or communist countries, Eastern Europe in the 1980s, for example, than we think we are. So educate yourself and fight back.
Wonderful. Well, Josh, thank you so much for walking us through the history and the recent challenges facing free speech in Canada. Your insights shed light on how legal shifts and government decisions are reshaping this very fundamental right. For anyone interested to dive into this topic further, we highly encourage you to read Josh's full essay, The Road to Censorship: How Canada Lost Its Way on Freedom of Speech, linked down in the description below. Thank you, Josh, again for being here. It was great to have you, and thank you for tuning in, everybody. We'll see you next time.